Welcome back to the Lawline Watch, where we break down real courtroom moments that'll leave your jaw on the floor. Today, we're stepping into Judge Middleton's courtroom, a no-nonsense judge known for his calm authority and fair-handed justice. The case? A defendant facing a felony methamphetamine charge and a lingering disorderly conduct offense. What unfolds next is a mix of redemption, accountability, and a surprising dose of judicial grace. Will the judge go easy, or will past behavior seal this defendant's fate? Let's find out. But first, buckle up because this one's a perfect storm of law, logic, and human emotion.
Good morning, Mr. Garn. Can you hear me?
Yes, Your Honor.
This is Judge Middleton. I'll be with you in just one sec. You had a felony matter this morning, possession of methamphetamine, and you waived preliminary examination in this matter, but there was also an old disorderly person charge hanging around. It's alleged that in September 23rd, let me actually pull it up. That you were a disorderly person at West Chicago in Ottawa. Alleged you were yelling at people and intoxicated. You've been in custody now. For 14 days. I would represent to you the same thing as I did with an earlier defendant. If you plead guilty to this charge, I'm going to give you 14 days in jail, credit 14 days, a minimum allowable fine concurrent with your other felony case. Do you understand?
Yes, I do.
All right. Are you willing to plead to being a disorderly person in Sturgis on September 23rd?
Yes, Your Honor.
Anybody threaten you to get you to do that?
No, but I was not made aware of it until just now.
Yeah, the ticket's been lurking around here. I just wanted to try to deal with it today and get one more thing off your plate.
Okay.
You understand that if you plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury. There will be no trial. Do you understand that?
Here's where things get really interesting. Judge Middleton isn't just moving through legal formalities, he's laying out the foundation of a plea bargain. The defendant is being offered a time-served deal, meaning his 14 days in custody will count toward the sentence. This approach saves the court time and gives the defendant a clean slate to focus on his more serious felony case. Notice how the judge walks him through every right he's waiving. The right to a trial, to an attorney, and to confront witnesses. It's methodical, respectful, and ensures the plea is legally airtight. Question for you, do you think the judge is being compassionate here, or just practical?
I do.
If you had a trial, you'd have the right to be represented by an attorney. If you could not afford an attorney, get appoint one for you at county expense.
I understand, Your Honor.
If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would also have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. You did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless they were able to prove your guilt beyond a reasonable doubt. All right. Other than what I told you about what I'm going to do for the sentence, did anybody promise you anything to get you to plead to this charge? Or threaten you?
No.
All right. Were you there in Sturgis on that day, September 23rd, yelling at people and being intoxicated?
I was intoxicated. I don't exactly remember yelling at anyone specifically, except maybe the officers on scene, but
All right, that's probably good enough. 14 days, credit 14 days. I'm gonna make it concurrent with your felony case, which is 251635 FH. And the fine is 0, but the state costs are $125 or 2 additional days, which will get swallowed up by the time you're already doing. All right, Mr. Garnis, one less thing you got to deal with. We'll deal with your methamphetamine case in the circuit court. This disorderly person case is done, and you're good to go. All right, thank you, sir.
And there it is, justice, efficient and direct. Judge Middleton finalizes the sentence, 14 days credited as time served, with the minor fines absorbed by the jail time already done. The judge's tone here is almost fatherly, acknowledging the mistake but giving the defendant space to move forward. This isn't just a case about punishment, it's about responsibility and closure. With the misdemeanor resolved, the focus now shifts to the larger felony ahead, a reminder that small wins can pave the way to bigger battles. What do you think? Was this outcome fair? Should leniency like this be shown more often? If you found this case as shocking as we did, make sure to hit that like button, drop your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns.